Welcome back to my YouTube channel. Friends, you all know that on 12th February of 2023, that is this year, UPPCS is going to have a UPPCS examination of prelims. So we are going to have a series of the previous years of question papers where we will solve all the question paper. तो हम लोग solve करेंगे कुछ पिछले साल के question paper को, and we will try to answer those questions so that whenever you are traveling or you are doing some kind of job, you can also see this video and you can refresh your memory and you can prepare for the prelims examination properly. So therefore we have this kind of series here. So this is the first video in this series. So today we are having this question paper of 2003 here. So let's start the question paper. Friends, you all know that in the UPPCSJ there would be 150 questions, and 50 question will come from the general studies. So we will discuss here mainly firstly that is the law subject, and then we will cover the other subjects also later on, so that we can finish all these revision works before the 12th February of this one. So you can have a revision even you are traveling, if you are doing something like work you can do. So चलिए शुरू करते हैं इसको. So my dear friends, this is the first question which you can see on the screen. That is, the application for anticipatory bail may be made before Chief Judicial Magistrate, High Court, Session Court, or the fourth option, both B and C. So my dear friends, you all know that the answer would be the D, because as per the section 438 of the CRPC, both Session Court and the High Court, they are competent to issue the bail, to issue the anticipatory bail. Therefore the answer would be D. Coming to the next second question, point out the incorrect statement. In cognizable offence, any police officer may, without an order from a magistrate and without a warrant, arrest any person. So we have to point out incorrect statement. Okay, a private person may arrest or cause to be arrested any person committing a cognizable offence. An executive magistrate may arrest the offender when any offence is committed in his presence within his jurisdiction. And the D, none of these. तो दोस्तों लोग आप बताइए कि इसमें कौन सा करेक्ट आंसर है. आई एम गिविंग फ्यू मिनट्स ऑफ द टाइम. So you will see that all the statements which are given here, they are correct. So there is no any incorrect statement. Therefore the answer is going to be the D. Now the next question which was asked in the 2003, the power of the Supreme Court to transfer case and appeals from one high court to the another high court can be exercised on an application by which one of the following. So अगर सुप्रीम कोर्ट जो है एक हाई कोर्ट से दूसरे हाई कोर्ट कोई एप्लीकेशन को ट्रांसफ़र करना चाहता है, अपील को ट्रांसफ़र करना चाहता है, तो उसके लिए कौन एप्लीकेशन दे सकता है. द ऑप्शंस विच आर गिवन हियर: रजिस्ट्रार ऑफ द हाई कोर्ट कंसर्न, अटॉर्नी जनरल ऑफ इंडिया, चेयरपर्सन ऑफ द बार काउंसिल ऑफ इंडिया, सोलिसिटर जनरल ऑफ इंडिया. आप लोग बताइए इसमें कौन सा आंसर करेक्ट है. So friends, you all need to see section 406 of the CRPC. Then you can find that the answer is Attorney General of India. So this is the right answer. So the Supreme Court will transfer case and appeals from one high court to another high court on the application which is going to begin by the Attorney General of India. Coming to the next question. Which section of CRPC provides for confirmation by the High Court of an order of a death sentence passed by session courts prior to its execution? So कौन सा section है CRPC का which says that, which empowers that for confirmation by the High Court of an order of death sentence passed by session court prior to its execution? So that you all know that whenever any death sentence has been given, it must be confirmed by the High Court. So which section says this? Section 366, 368, 369, 371. So give the answer. Yes, you are right. This is the section 366. So this is how you can find here. Now next question is, which one of the following statement is wrong? So we have to find out the wrong statement here. If a person forcibly resists the endeavor to arrest him, the police officer may use all the means necessary to effect the arrest, cause the death of such person irrespective of the offense he has committed, cause the death of such person accused of murder, cause the death of such person accused of culpable homicide not amounting to murder. So बताइए आप लोग इसमें कौन सा wrong statement है? So the right answer, the wrong statement which is here, that is B. Cause the death of such person irrespective of the offense he has committed. So the police officer has to take into account that what kind of the offense he has committed. He can't take away someone's life of any kind of the, if he is accused of any kind of the offense. Okay, so this is how you can find here, and for this you need to refer section 46 of the CRPC. अगर आप सेक्शन 46 CRPC को देखेंगे तो वहाँ पे ये प्रावधान दिया हुआ है. Now coming to the next question, point out the incorrect response. The period of limitation for taking cognizance of an offence shall be 6 months if offence is punishable with fine only, 1 year if the offence is punishable with the imprisonment for a term not exceeding 1 year, 3 years if the offence is punishable with imprisonment for a term not exceeding 1 year but not exceeding 3 years, and the last option is 5 years if the offence is punishable with the death sentence. Now now please let me know which is the incorrect response here among these. Take your time, and the answer is this, D, 5 years if the offence is punishable with the death sentence. So for this, my dear friends, you all need to refer section 468 clause 2 of CRPC. Now moving towards the next question, in which case the Supreme Court has held section 125 CRPC was applicable to all irrespective of their religion. So option is Muhammad Umar Khan versus Gulshan Begum, Muhammad Ahmad Khan versus Sahabano, Muhammad Johra Khatun versus Muhammad Ibrahim, Noor Sabah Khatun versus Muhammad Qasim. Now let me know which is the right answer. बताइए इसमें right answer कौन सा है? Yes, you all are right. The answer is very famous case. You know that, Muhammad Ahmad Khan versus Sahabano Begum. Moving towards the next question, which of the following offence is not compoundable? Section 323, Section 334 of the IPC, Section 448 of the IPC, Section 307 of the IPC. So which one of the offence is not compoundable from this list? So बताइए आंसर कौन सा इसका है? Yes, you all know that section 307, attempt to murder of the IPC is non-compoundable offense. Okay, moving to the next question. The next question which is here, this is the matching list which was asked in the 2003. So we all need to do a matching list from 1 to the list 2. So list 1 says about security for keeping peace on conviction, security for good behavior from suspected person, security for behavior from habitual person, security of keeping peace in the other cases. Now the sections which are given here, section 110, section 109, section 107, section 106. तो इसमें कौन सा सेक्शन किस प्रोविजन को में बताता है? We have to give the answer. So just do this matching. I am giving few minutes to you. इसमें से कौन सा सेक्शन किस प्रोविजन को मैच कर रहा है आपको ये बताना है. ए किसके साथ है, बी किसके साथ है, सी किसके साथ है और डी. तो राइट आंसर इज हियर दिस वन, बिकॉज इफ यू सी दिस सिक्योरिटी फॉर कीपिंग पीस ऑन कन्विक्शन, ये जो है सेक्शन 106 का है. Security for good behavior from suspected person, this is section 109. Security for good behavior from habitual person, this is here the section 110. 10. And security for keeping peace in other cases, this is belonging to the section 107. So the right answer is here B. Moving towards the next question, which section of the CRPC provides that the public prosecutor in charge of a case may, with the consent of the court at any time before the judgment is pronounced, withdraw from the prosecution of any person in respect of any offence for which he is tried. When the public prosecution in charge of any case with the consent of the court can विड्रॉ द प्रोसिक्यूशन, कौन सा सेक्शन ऐसा है जो सीआरपीसी का जो कि पब्लिक प्रोसिक्यूटर को विड्रॉ करने के लिए परमिशन देता है अगर वो कोर्ट से कंसेंट मिल जाता है? ऑप्शन विच आर गिवन हियर, सेक्शन 304 ऑफ द सीआरपीसी, सेक्शन 321, सेक्शन 306, सेक्शन 313. कौन सा सेक्शन है आप बताइए हमें. यस, यू आर राइट, दिस इज द सेक्शन 321 ऑफ द सीआरपीसी which says that the public prosecutor can withdraw the case with the consent of the court of any offence which he is trying. Okay. Another question which was asked in the 2003, which one of the following sections of the Indian Evidence Act has been substituted for the old section of the IT Act 2000? So कौन सा सेक्शन है जो कि सब्स्टिट्यूट हुआ है IT Act के से, वो पुराना सेक्शन कौन सा है? The options are section 39, section 47, section 22, section 65. Give the right answer. I am giving few minutes to you. Yes, you are all right. That is the section 39, because in this case the other sections they had not been substituted, rather than few another sections has been added. For example, section 22 has another section, section 22A. Section 65 has another section, that is section 65A. 47 has another provision, 47A. लेकिन 39 जो था उसमें कहीं भी कुछ नया ऐड नहीं किया, बल्कि इसको सब्स्टिट्यूट ही किया गया प्रोविज़न को. ओके, बाकी में क्या हुआ, कोई सब्स्टिट्यूट नहीं किया बल्कि कुछ प्रोविज़न ऐड किए गए. नाउ अनदर क्वेश्चन, which one of the following is not included in the expression code under the Indian Evidence Act? ये क्वेश्चन काफ़ी पॉपुलर है, काफ़ी कई बार पूछा जाता है. Now let's see what are the option was given. All judges, all person legally authorized to take evidence, all magistrate, arbitrator. इसमें से कौन सा राइट आंसर है आप लोग बताइए. Yes, the right answer is this one, arbitrator. Arbitrator is not the code under the Indian Evidence Act. And the answer where you can find this one, that is section 3 of the Evidence Act, which has a definition of the court. The case of Sawal Das versus State of Bihar is related to which kind of the provision of the Indian Evidence Act? Plea Sawal Das versus State of Bihar, plea of LB, rule of res geste, rule of estoppel, rule of res judicata. Just let me know which is the right answer here. Yes, the right answer is rule of res geste. Moving towards the next question, that is question number 14 here. Which section of the Indian Evidence Act makes this provision that there shall be no trial on the ground of improper admission of rejection of evidence? So the options which are given, the section 166, 165, 167 and 161. And which is the right answer? Just let me know from your side. Here this question you can see here. कौन सा right answer है? Yes, you are all correct. That is section 167. Now the next question is, a confession by an accused can be used against a co-accused under section 30 of Evidence Act as hearsay evidence, only as a corroborative evidence, as substantive evidence, or D, none of the above. Let me know which is the right answer. Yes, the evidence of the co-accused person is going to be considered not as a hearsay, not as substantive evidence. It would be only a corroborative evidence here. So the right answer is B. The other question which was asked, under section 57 clause 1 of the Indian Evidence Act, the court shall take judicial notice of all laws in force in India, all laws including foreign laws, all Indian and Asian laws, all Indian and British laws up to the 1950. So which is the right answer here? Yes, the right answer is that all laws in force in India. So this is the right answer. Under section 57 clause 1, the court will take the judicial notice of the all laws in force in India. The case of Pakalanaya Swami versus Emperor, which it relates to which kind of the doctrine? Doctrine of estoppel, accomplice, dying declaration, or the cross examination. So my dear friends, you all know that the very famous case, yes, it belongs to the dying declaration. Moving towards the next question, question number 18. A commits a crime and goes to police officer. He makes confession and give other information. A is charged with the offense, the confession. So now the confession cannot be proved against him because of section 25 of the Evidence Act. Can be proved against him because of section 27 of the Evidence Act. Can be proved against him because of section of 25. Can be proved because of section 25 of the Evidence Act. Cannot be proved against him because of the section 27 of the Evidence Act. So my dear friends, you all know that whenever any person is making a confession before the police officer, that information or that confession can't be proved against him. So therefore, as per section 25 of the Evidence Act, it can't be proved against this person. Now moving towards another question, that is, which of the following statement is incorrect regarding dumb witness? A dumb witness may give his evidence by writing in open court. A dumb witness may give his evidence by signs in open court. A dumb witness can give evidence gained by evidence in a writing before the court shall be deemed to be a documentary evidence. And the last option, a dumb witness may give evidence in any manner which can make it intelligible. So which is the right answer? The right answer is C. A dumb witness, that dumb witness means who can't speak. So a dumb witness can give evidence in writing, and that evidence is going to be considered as a documentary evidence. Moving towards the next question. In a trial of murder of B by A, which fact is not relevant? So if a trial is going of murder against B and any statement by A, which fact is not going to be relevant here? The first one, A was absconding immediately after the murder of B. A and B were seen together before murder. A had borrowed ₹50,000 from B. A was in Bombay on that day while murder of B was committed in Chennai. So now friends, just give me the answer here. Which is the right answer? Yes, the right answer is A had borrowed ₹50,000 from B. So this is not a relevant fact in this case as per the section 5. So for section 5, if you just go, you will find this kind of the illustration here of from the Indian Evidence Act. Okay. Now moving towards another question. Any question suggesting the answer which the person putting it wishes or expects to receive is called. So now what kind of the things would be there? Whether it would be indecent question, scandalous questions, question intended to annoy, leading questions. So कौन सा आंसर होगा यहाँ पे? Just give me the answer. So a question which has been asked, which is suggesting some kind of answer, that is being called as a leading question. And this is very important section for mains also. Section 141 of the Indian Evidence Act is the right answer where you can find the answer to this. Now moving to another question, matching question number 22. Which of the following combinations are not correctly matched? Okay, so we have to find out the correct code here. Okay, so voluntary and direct acknowledgement of guilt, admission, then self-exculpatory confession of accused, that is cannot be used against co-accused when confessing accused is not on trial. Extrajudicial confession corroboration is must. Evidence of police officer can be take as expert opinion. So we have to find out the correct answer using the correct code. So but that we have to see which is not correctly matched here. Okay, now my dear friends, just give me answer here. Yes, the right answer is B. This is voluntary and direct acknowledgement of guilt, admission, and then this one extrajudicial confession needs corroboration is must. So these are not correctly matched. Okay, now coming to the next question, that is, under the provision of section 146 clause 3 of the Evidence Act, in a prosecution for the rape, in her cross examination the prosecutrix can we put question as to her general immoral character? With the permission of the court, can we put question as to her general immoral character? The cannot be put question as to her general immoral character, cannot be put question as to her rape. Yes, so which is the right answer? Yes, this is the right answer, C. Because during the prosecution of the rape, the prosecutrix, that means against whom the rape was committed, for that girl or that woman, you can't ask any question with respect to her general immoral character. It is not permissible even without the consent of the court as well. Okay, and that is which you all need to understand, that the laws are like that, where the in the prosecution of the rape, you can't ask any question with respect to the character of the girl or the women. Okay, moving to the next question, which one of the following is a correct statement relating to क्रॉस एग्जामिनेशन? सो कौन सा स्टेटमेंट क्रॉस एग्जामिनेशन के लिए करेक्ट है? द फर्स्ट इज विटनेस टू करेक्टर मे बी क्रॉस एग्जामिन. सेकेंड, लीडिंग क्वेश्चंस कैन नॉट बी आस्क्ड इन क्रॉस एग्जामिनेशन. अ पर्सन समवन टू प्रोड्यूस अ डॉक्यूमेंट कैन बी क्रॉस एग्जामिन्ड. अ विटनेस may not be cross examined as to previous statement made by him in writing. So we have to identify which is the correct statement regarding the cross examination. So just let me know which is the right and correct statement. Yes, this is the right answer. Witness to character may be cross examined, and you can see the section 140 of the Indian Evidence Act as well for the reference of the answer here. Moving towards the next question, burden of introducing evidence under section 102 of the Evidence Act shifts at a time, never shifts, constantly shifts, none of this. Which is the right answer? Yes, you are all correct. The right answer is it constantly shifts. So this is how under section 102 of the Indian Evidence Act the burden of proof shifts from one person to the another person. Okay, now Civil Procedure Code, that is UP Amendment Ordinance 2003, it relates to which kind of the provisions? However, this is a very old ordinance, maybe not relevant here for your examination, but just for the sake of the question here, we are going to answer here. So this was ordinance with respect to section 115 of the CPC. Okay, moving to another question, which one of the following is not a rule of pleading? So which is not a rule of pleading? Number one, plead the fact and not the law, state the law and plead the fact, plead immaterial facts only, plead material facts only, plead facts not evidence. So which is the right answer? Yes, state the law, plead the facts. You need to plead the fact, not the law here. So this is the right answer, and for that you can go to the provision of the order 6 rule 2 of the CPC, from where you can get the answer to this question. Another question, which one of the following combinations are not correctly matched? Okay, now let's see which is not correctly matched. So we have to find out the code which is not correctly matched. So res sub judice section 111, res judicata section 10, judgment and decree section 33, summon to witness section 80. So which is the right answer, my friend? Just let me know. ओनली दिस इज करेक्टली मैच, बाकी जो है वो करेक्टली मैच नहीं है, बिकॉज रेस सब्जुडाइज क्या है वो सेक्शन 10 में आता है, रेस जुडिकेटा सेक्शन 11 में आता है, समन्स टू विटनेस जो है वो सेक्शन 80 में नहीं आता है, वो 31 में आता है। तो इसलिए 1, 2 and 4 this is not correctly matched, so the answer is B here. Now moving to another question. Which one of the following cases is related to the principle of res judicata? इसमें से कौन सा केस जो है रेस जुडिकेटा से रिलेट करता है? सत्यचरण वर्सेस देवरंजन, MS कोऑपरेटिव मार्केटिंग फेडरेशन लिमिटेड वर्सेस इंडियन बैंक बॉम्बे, PC जयरा वर्सेस अमृत जयरात, ऑल ऑफ दी एबव। कौन सा है बताइए आप लोग। यस, द राइट आंसर इज सत्यचरण वर्सेस देवरंजन, ये राइट आंसर है। दिस केस बिलोंग्स टू द रेस जुडिकेटा। अनदर क्वेश्चन, where the local limits of jurisdiction of courts are uncertain, the place of institution of suits can be decided according to which section of the CPC? अगर ये तय नहीं है कि कहाँ पे केस फाइल हो सकता है और जुरिडिक्शन को लेके कोर्ट के बीच में अनसर्टेनिटी है, तो CPC का कौन सा प्रोविजन हेल्प करता है? माय डियर फ्रेंड्स, जस्ट गिव मी द आंसर हियर, वेदर सेक्शन 17, 18, 19 and 20. Okay. So the right answer is here, that is section 18 of the CPC, which says that in case of any confusion happens between the courts where the jurisdiction should lies, this section 18 will help. Okay, all civil courts have jurisdiction to try all suits of civil nature, all suits civil nature except suits with their cognizance. So all civil courts have jurisdiction to try all suits of civil nature, all suits civil nature except suits of which their cognizance is expressly not barred, all suits of civil nature except suits of which their cognizance is impliedly not barred, all suits of civil nature except suits which their cognizance is expressly or impliedly barred. So just give me the answer. Yes, you all are correct. The answer is all suits of civil nature except suits which their cognizance is expressly or impliedly barred. So therefore what you find that section 9 of this CPC is going to give the answer to this question. Another question, in which one of the following case it was held that inherent power has not been conferred on a court, it is a power inherent in a court? किस केस में ये कहा गया था इनहेरेंट पावर हैज नॉट बीन कन्फर्ड ऑन अ कोर्ट, इट इज अ पावर इनहेरेंट इन अ कोर्ट? सो द ऑप्शंस विच आर गिवन हियर, मनोहर लाल वर्सेस सेठ हीरालाल, कॉटन कॉर्पोरेशन ऑफ इंडिया वर्सेस यूनाइटेड इंडस्ट्रियल बैंक, सत्यव्रत विश्वास वर्सेस कल्याण कुमार किस्कू, रंजन बाई वर्सेस कमला देवी। कौन सा इसमें राइट आंसर है? जस्ट लेट मी नो फ्रेंड्स, आप बताइए कौन सा राइट आंसर है इसमें। Yes, the right answer is Manohar Lal versus Seth Hiralal, and it relates to section 151 of the CPC. CPC के सेक्शन 151 जो है वो इनहेरेंट पावर की बात करता है कोर्ट्स के, हाई कोर्ट्स के। एन अपील शैल लाई फ्रॉम अ डिक्री पास बाय ए कोर्ट विद द कंसेंट ऑफ पार्टी इफ इट इज प्रोवाइडेड अंडर विच provisions of the CPC, which section? Section 96 clause 1, 96 clause 2, 96 clause 3, 96 clause 4। किस सेक्शन के CPC किस सेक्शन में ये प्रावधान है कि an appeal shall lie from a decree which has been passed by a court with the consent of the parties? And the right answer is section 96 clause 1 of the CPC. And next question is, under order 8 rule 6 of CPC, set off may be permitted if the suit is recovery of property or set of claim by defendant is a certain sum of money. Value of property recoverable is less than rupees 2 lakhs. Defense defendant present a written statement of the suit. So which is the right answer here, my dear friend? Just let me know. Yes, the right answer is the set of claimed by the defendant is a certain sum of money. The B option is correct. Now let's come to this next question. Which of the following combinations are correctly matched? Combinations which are correctly matched here. So temporary injunction, order 39, whether it is correctly matched. Sued by indigent person, order 33, whether it is of the CPC, whether it is correctly matched. Power of appellate court with section 102 of the CPC, whether it is correctly matched. Right to file caveat, which is given under section 148A. So which is correctly matched? Just let me know the answer, my dear friends. क्या टेम्पररी इंजंक्शन ऑर्डर 39 में है? क्या सूट बाय इंडिजेंट पर्सन ऑर्डर 33 में है? क्या इसमें से कौन सा जो है वो करेक्टली मैच्ड है? जस्ट गिव मी द आंसर हियर. Yes, you are all correct. Only this one, temporary injunction, sued by indigent person, and right of caveat person is correctly matched. So the answer is this one, A. Moving towards the next question. Point out incorrect answer. A decree passed by a civil court can be executed by the court which has passed this decree, the court to which the decree transferred for execution by the court passing the decree, any court having jurisdictions concurrent to the court that passed the decree, and the last, either by court A or B as above. So now which is the right answer? Just let me know. Yes, the right answer is D, because in both the cases the court which has passed the decree and the court to which the execution has been transferred, that can be also execute the decree. So this is the right answer. Okay, now moving towards the next section, section 37. Question number 37. A civil court cannot issue commissions on the following cases. A civil court can't issue, okay, for examining a person, for examining account, to execute partition, to execute a decree. Which is the right answer? Let me know. Yes, D. The court can't issue a commission to execute a decree. So for this, section 75 of the CPC has the answers, where you can find that for what purpose the court, civil court, can issue a commission. Okay, now moving to the next question. Which of the following combinations are correctly matched? Equity of judgment, debtor, section 49 of the CPC. Privileged document, section 29 of CPC. Legal representative, section 50 of CPC. Pauper suit, section 33 of the CPC. So which of the following combinations are correctly matched? Select correct answer using the code. Now just let me know the answer. Just go to this question and let me know the answer. I hope that you have understood the right answer. So just let me know which is the right answer. Yes, this is the D. Except to the rest or the properly matched correctly. 1, 3 and 4, they are correctly matched. This is not the correct match. Next question. Which section of Civil Procedure Code prohibits arrest or detention of women in the execution of decree for money? Now answers are section 55, section 59, section 56, section 60. So just give me the answer here. The right answer is section 56. Section 114 of CPC should be read with which order and rules? The first option, Order 46 Rule 1, Order 47 Rule 1, Order 47 Rule 3, Order 41. Now just give me the right answer. Yes, Section 114 of CPC should be read with the Order 47 Rule 1 of the CPC. Now coming to the questions from the jurisprudence here, my dear friends, you all know that in the UP prelims examinations, there are certain questions which are going to be asked from the jurisprudence here. Okay, now the first question from the jurisprudence, and the question number 41 is here. That is, who categorized the subject of jurisprudence as expositorial jurisprudence and censorial jurisprudence? Holland, Bentham, Kelson, and Patton. Who was the person who has categorized in the two categories? And the right answer, yes, you are all correct, that is Bentham. Bentham has categorized jurisprudence as subject of expositorial jurisprudence and censorial jurisprudence. Another question, who described jurisprudence as lawyer's extraversion? The options which are given is Savigny, Salmon, Julius Stone, Buckland. And which is the right answer? Just let me know from your side. Comment करें. Yes, you are right. The right answer is, who had said that it is lawyer's extraversion? That is the person who is, that is the Julius Stone. Julius Stone is the person. Okay, moving to another question about the positive approach of law. Who said this is a confluence of command, sanction, and sovereignty? Options are Hart, Austin, Holland, Kelson. ये तो बहुत easy question है. Which is the right answer? Just do comment in the comment box. कौन सा right answer है यहाँ पे? It is a confluence of command, sanction, and sovereignty. The word is confluence. Yes, Hart. Okay. Now another question, the constitutional basis of president in India is from which article? Article 141, Article 136, Article 14. Which article is this? Just let me know the answer. Yes, the right answer is Article 141. Moving to the next question. Fiction theory is related to which of the following concepts? Ownership, liability, justice, legal personality. किससे है फिक्शन थ्योरी? किससे रिलेट करता है? प्लीज डू द कमेंट. आंसर कमेंट करके बताइए. Yes, the right answer is legal personality. The next question, which of the following acts protect the possessions concept? CRPC, Specific Relic Act, both A and B and D, none of the above. कौन सा एक्ट प्रोटेक्ट करता है पोजीशन के कॉन्सेप्ट्स पे? Yes, the right answer is in Specific Relief Act. Moving to the next question. Which theory is not connected with the concept of the property? The natural law theory, लेबर थ्योरी, साइकोलॉजिकल थ्योरी, रियलिस्टिक थ्योरी. कौन सा थ्योरी प्रॉपर्टी के कॉन्सेप्ट से रिलेट नहीं करता है? इसका राइट आंसर आप कमेंट बॉक्स में करके बताइए. कौन सा है आंसर इसका करेक्ट? यस, द राइट आंसर रियलिस्ट थ्योरी, बिकॉज इट बिलोंग्स टू द पर्सनालिटी, लीगल पर्सनालिटी थ्योरी. लीगल पर्सनालिटी की थ्योरी में आता है रियलिस्ट थ्योरी. देयरफॉर दिस इज द राइट आंसर. नेक्स्ट क्वेश्चन इज, in the Dark Age, natural law was given a new interpretation by whom? Saint Augustine, Thomas Aquinas, Paul European. किसने इसको डार्क एज में नेचुरल लॉ के थ्रू किया? आंसर कमेंट में आंसर कीजिए. Yes, the right answer is Saint Augustine. So this is the right answer. Coming to the next question, who has rejected the concept of right as immoral against the interest of the society? किसने जो है राइट के कॉन्सेप्ट को इमोरल एंड अगेंस्ट द इंटरेस्ट ऑफ द सोसाइटी का कॉन्सेप्ट जो है उसको रिजेक्ट किया इस कहते हुए कि राइट ऐसा नहीं है? आंसर कमेंट करके बताइए. यस, द आंसर इज डुगिट. डुगिट हैड सेड सो. लास्की, एडवर्ड जेंग्स, बकलैंड एंड डुगिट में से डेविड इज द राइट आंसर. Now, the Frederick Cole von Savigny has observed custom precede legislation. Legislation must conform to customary practices. Custom is not important than legislation. Custom is superior to legislation. इसमें से कौन सा करेक्ट आंसर वाला कोड है, कौन सा करेक्ट है, कौन कौन से पॉइंट सेवनी ने बोला है, इसको आप बताइए इधर कमेंट करके. क्या कस्टम प्रिंस लेजिस्लेशन, लेजिस्लेशन मस्ट कंफर्म टू कस्टमरी प्रैक्टिसेस, कस्टम इज नॉट इंपॉर्टेंट देन लेजिस्लेशन, कस्टम इज सुपीरियर टू लेजिस्लेशन. इसमें से कौन कौन से स्टेटमेंट सेवरी ने बोले हैं? सी कस्टम को काफी इम्फेसिस किया है सेवरी ने. सो कस्टम इज नॉट इंपॉर्टेंट देन लेजिस्लेशन, ये जो है ये करेक्ट स्टेटमेंट नहीं है. देयरफॉर द रेस्ट ऑफ द स्टेटमेंट्स आर करेक्ट. That is, custom precedes legislation. Legislation must conform to customary practices, and custom is superior to legislation. So these are the right observations was made by the. These are the observation which was made by Savigny. So the answer is 1, 2, and 4. Kelson's theory of law is called pure theory because Kelson की theory pure theory क्यों कहलाती है? Because purely discuss jurisprudence only, defined law in accordance with the morality and purity, separated law from religion, ethics, sociology, and history. डिस्कस लॉ प्योरली इन टर्म्स ऑफ जस्टिस. कौन सा राइट आंसर है? क्यों प्योर थ्योरी कहते हैं? यस, आंसर कमेंट करके बताइए. यस, द राइट आंसर इज दिस वन, बिकॉज इट सेपरेट्स लॉ फ्रॉम रिलीजन, एथिक्स, सोशियोलॉजी एंड हिस्ट्री. इसलिए इसको बोलते हैं प्योर थ्योरी ऑफ लॉ. लॉ का इससे कोई मतलब नहीं है कि रिलीजन क्या है, एथिक्स क्या है, सोशियोलॉजी क्या है, हिस्ट्री क्या है. इसलिए इसको प्योर थ्योरी ऑफ लॉ बोलते हैं. Coming to the next question, the law declared by Supreme Court is binding on all courts within the territory of India, but the Supreme Court is not bound by its own decision. In which case the Supreme Court has held this one? The options which are given here: Bengal Immunity Company Limited versus State of Bihar, Keshwanand Bharti versus State of Bihar, Indira Nehru Gandhi versus Rajnarayan, Madhav Raj Sindhia versus Union of India. कौन सा right answer है? Please just let me know the answer. आंसर कौन सा है इसमें? कमेंट करके बताइए. यस, द आंसर इज बंगाल इम्यूनिटी कंपनी लिमिटेड वर्सेस स्टेट ऑफ बिहार, वेयर सुप्रीम कोर्ट हैड सेड दैट all the courts are binding by the judgment of Supreme Court, but the Supreme Court itself is not bound by its own decision. Okay, moving towards the next question, question number 53. Who has made a distinction between law property so called and law improperly so called? Law properly so called और improperly law so called में डिफरेंस किसने किया? नाउ द ऑप्शंस विच आर गिवन हियर: जर्मी बेंथम, G.W. पैटर्न, जॉन ऑस्टिन एंड होम्स. किसने डिफाइन किया? हु हैज मेड दिस काइंड ऑफ डिस्टिंक्शन दैट लॉ प्रॉपरली सो कॉल्ड एंड लॉ improperly so called? Yes, the man is John Austin, who has defined the law in two categories: improper law and proper law. Analytical, historical. Moving to the next question. Analytical, historical, and ethical jurisprudence are three different parts of jurisprudence. According to whom? Salmond, Hearing, H.L.A. Hart, Immanuel Kant और Salmond. किसने कहा ऐसा? Yes, the answer is Salmond. Salmond had said that analytical, historical, and ethical jurisprudence are three different parts of jurisprudence. Now the next question is, national character of law was introduced in jurisprudence by whom? By Karl Marx, by Savigny, by Montesquieu, Hans Kelsen. So just give me the answer through the comment. Just put your answer in the comment box so that we can see in the chat box, in the comment box. किसने नेशनल कैरेक्टर ऑफ लॉ लाया? Yes, the right answer is Savni. Savni belongs to the historical school, and he says that the law must be as per the nation, as per the history of the nation. Now coming to the next question, possession through an agent or servant is an example. जब कोई पोजीशन होता है एजेंट या सर्वेंट के थ्रू, उसको किस प्रकार का पोजीशन बोलते हैं? वेदर इट इज इमीडिएट पोजीशन, इनकॉर्पोरल पोजीशन, मीडिएट पोजीशन और कॉर्पोरियल पोजीशन. कौन सा राइट आंसर है? कमेंट करके बताइए बॉक्स में. प्लीज राइट योर आंसर इन द कमेंट बॉक्स. विच इज द करेक्ट आंसर? whenever any property is coming through an agent or servant, whether it is immediate or mediate, corporeal, incorporeal. Yes, the right answer is mediate, because it is not coming immediately to you, it is coming through the mediate, so therefore it is a mediate position. Now the next question, the main purpose of the corporation soul is, the option is to make the property easily inheritable, second, make the property easily transferable, maintain continuity of an office, maintain continuity of an office, project the property of state. इसमें से कौन सा मेन पर्पस है कॉर्पोरेशन सोल का? जस्ट गिव मी द आंसर. कमेंट बॉक्स करके बताइए, बॉक्स में कमेंट बॉक्स में कमेंट करके बताइए, चैट बॉक्स में. यस, द राइट आंसर इज मेंटेन द कॉन्टिन्यूटी ऑफ एन ऑफेंस. इन विच ऑफ द फॉलोइंग केस द सुप्रीम कोर्ट हेल्ड that the secularism is the basic structure of the constitution? This is a very important case. There is no case like Keswananda Bharati, so you have to make answer from these judgments. So in which case the court had said that the secularism is the basic structure, whether this is case of SP Mittal, Sri Jagannath Temple versus Puri Management Committee, Aruna Roy versus Union of India, or none of the above. So my dear friend, the answer is SR Bommai, and this answer is not given here. So this is how you can find here. Now moving to the next question, in which of the following case it was ruled that the government servant has no right to go on strike? किस केस में कहा गया है गवर्नमेंट सर्वेंट स्ट्राइक पे नहीं जा सकते हैं? एंड द ऑप्शन विच आर गिवन हियर, TR रंगराजन वर्सेस स्टेट ऑफ तमिलनाडु, जावेद वर्सेस स्टेट ऑफ हरियाणा, श्याम नारायण चौकसी वर्सेस यूनियन ऑफ इंडिया, चेहक वर्सेस यूनियन ऑफ इंडिया. विच इज द राइट आंसर? देखिए, जावेद वर्सेस स्टेट ऑफ हरियाणा इज अबाउट द 2 चाइल्ड पॉलिसी. दिस इज द श्याम नारायण चौकसी केस. इट इज नॉट ऑन द स्ट्राइक. दिस इज अनदर केस विच इज नॉट ऑल्सो ऑन द स्ट्राइक. द राइट आंसर इज TR रंगराजन versus state of Tamil Nadu, where the Supreme Court has ruled that the government servant has no right to go on strike. Moving to the next question, which of the following are included in the list of fundamental duties in the Constitution? इसमें से कौन सी ड्यूटी फंडामेंटल ड्यूटीज के लिस्ट में है? The first one, to abide by the Constitution and respect its institution, to safeguard public property and to abjure of violence, to uphold and protect the sovereignty, unity and integrity of the India, to uphold and protect secularism. So कौन सा ड्यूटी है जो कि फंडामेंटल ड्यूटीज में है? जस्ट गिव द आंसर हियर. सो दिस ड्यूटी टू अपहोल्ड एंड प्रोटेक्ट सेकुलरिज्म, ये फंडामेंटल ड्यूटी का पार्ट नहीं है, एंड देयरफॉर द आंसर इज 1, 2 and 3. सो दिस इज द पार्ट ऑफ द फंडामेंटल ड्यूटीज. A law which disqualifies a person with more than 2 children from holding the post of Panch Sarpanch is valid and not violative of Article 14 of the Constitution. In which of the following recent case the Supreme Court gave such decision? PUCL versus Union of India, Javed versus State of Haryana, Indra Jaising और मोहम्मद असलम वर्सेस यूनियन ऑफ इंडिया. इसमें से किस केस में सुप्रीम कोर्ट ने कहा कि जब आप सरपंच या पंच की पोजीशन पे हैं तो आप 1-2 से ज़्यादा बच्चे नहीं रख सकते हैं? कमेंट करके आंसर बताइए. बहुत पॉपुलर केस है. चैट बॉक्स में कमेंट करके बताइए. यस, द आंसर इज जावेद वर्सेस स्टेट ऑफ हरियाणा. कमिंग टू द नेक्स्ट क्वेश्चन. नाउ दिस इज अबाउट द मैचिंग द लिस्ट. मैच लिस्ट एंड लिस्ट 2 एंड सेलेक्ट करेक्ट आंसर यूजिंग द कोड गिवन बिलो द लिस्ट. हम यहाँ पे मैचिंग करना है. फ्रीडम ऑफ असेंबली, फ्रीडम ऑफ प्रोफेशन, ट्रेड एंड ऑक्यूपेशन, फ्रीडम ऑफ स्पीच, फ्रीडम ऑफ एसोसिएशन. विच बिलोंग्स टू विच आर्टिकल्स? ओके, रिस्ट्रिक्शन किस किस आर्टिकल में है? सो फ्रीडम ऑफ असेंबली आर्टिकल 19 क्लॉज 2, आर्टिकल 19 क्लॉज 4, आर्टिकल 19 क्लॉज 3, 19 क्लॉज 6. किस किस से बिलोंग करता है? कमेंट करके बताइए बॉक्स में. Yes, the right answer is A, because the restriction with respect to the freedom of speech and expression. So freedom of assembly restrictions are given in this Article 19 Clause 3. Profession and trade has been given in the 1906. Freedom of speech given in 1902, and freedom of association given in the 1906. So the right answer is A. Moving towards the next question, which what cannot be done directly cannot be done indirectly. This statement relates to which kind of doctrine? Ancillary power, pith and substance, कलेबल लेजिस्लेशन, इम्प्लाइड पावर. किससे रिलेट करता है कि जो आप डायरेक्टली नहीं कर सकते उसको आप इनडायरेक्टली भी नहीं कर सकते हैं. कमेंट करके बताइए आंसर. यस, यू आर राइट, दिस इज द कलेबल लेजिस्लेशन. दिस इज द राइट आंसर. Who was the chairman of the National Commission to review the working of the Constitution? Now this is no more important question to all of you, but however it may be asked sometimes because of this question may be asked. So कौन सा है जो review of the working of Constitution में बनाया गया chairman? And the right answer is Justice M.N. Venkat Chelaiya, who was the chairman of this National Commission to review the working of the Constitution. Now coming to the next, who among the following holds his office at the pleasure of the President? इनमें से कौन प्रेसिडेंट के प्लेजर पे पोजीशन होल्ड करता है? स्पीकर ऑफ द लोकसभा, अटॉर्नी जनरल ऑफ इंडिया, कैग, कॉम्प्ट्रोलर एंड ऑडिटर जनरल ऑफ इंडिया, चेयरमैन ऑफ द यूनियन पब्लिक सर्विस कमीशन. कौन इसमें जो है प्रेसिडेंट के प्लेजर पे पोजीशन को होल्ड करता है? कमेंट करके बताइए आंसर. आई एम वेटिंग फॉर योर रिस्पॉन्स. यस, द राइट आंसर इज अटॉर्नी जनरल ऑफ इंडिया. Article 76, Clause 2. It gives the answer to this. This question is disputes between states in India come to the Supreme Court under which jurisdiction? Appellate, original, advisory, review jurisdiction. कमेंट करके बताइए कि जब डिस्प्यूट होता है स्टेट्स के बीच में वो सुप्रीम कोर्ट के किस जुरिडिक्शन में आता है? आंसर कमेंट करके बताइए. यस, यू आर राइट, द आंसर इज ओरिजिनल जुडिक्शन, दैट इज आर्टिकल 131 of the Indian Constitution. Now Parliament has power to legislate with respect to a matter in the state list provided it is in the national interest of the minority, interest of the public, interest of the state concerned. किस लिए जो है स्टेट लिस्ट में पार्लियामेंट को राइट है कि वो लॉ बना सकता है, कब कब बना सकता है? यस, कमेंट करके बताइए आंसर. आई एम वेटिंग फॉर योर रिस्पॉन्स. यस, द पार्लियामेंट कैन मेक द लॉज फ्रॉम द स्टेट लिस्ट in the name of the national interest, and the answer is given here in the article 249 of the Indian Constitution. Okay, so you refer this article to article 249, you will get the answer from there. Now the constitutional authority vested with the power of declaring castes or tribes as scheduled caste or scheduled tribe is, किसके पास ये राइट है कि वो डिक्लेयर करेगा कौन शेड्यूल कास्ट है, कौन शेड्यूल ट्राइब्स है? विद पार्लियामेंट, चेयरमैन ऑफ SC/ST कमीशन, प्रेसिडेंट ऑफ इंडिया, होम मिनिस्टर. इसमें से कौन करता है? हु विल डू दिस? हु विल टेक द डिसीजन ऑन दिस वन? जस्ट गिव मी द आंसर. पुट योर आंसर इन द कमेंट बॉक्स. वेटिंग फॉर योर रिस्पॉन्स. यस, द राइट आंसर इज हियर, दैट इज द प्रेसिडेंट ऑफ इंडिया. प्रेसिडेंट ऑफ इंडिया will declare. Next question, what is imperative to show the requisite respect to the national anthem? Sing and stand respectfully, or sing the same, or the last option is to bow. कौन सा राइट ऑप्शन है कि जब आप नेशनल एंथम चल रहा हो आप अपना रिस्पेक्ट शो कर सकते हैं? किसके थ्रू? कौन सा प्रॉपर तरीका है? सिंग एंड स्टैंड रिस्पेक्टफुली या स्टैंड करना ही काफ़ी है? कमेंट करके बताइए. उस पर काफ़ी कंट्रोवर्सी हो जाती है कभी कभी साल 2 साल में. समटाइम्स यू विल फाइंड दैट इन ईच ईयर देयर वुड बी सम कंट्रोवर्सी ऑन द नेशनल एंथम. सो यस, द आंसर इज स्टैंड रेस्पेक्टफुली. दिस इज द राइट आंसर. अगर आप रेस्पेक्टफुली स्टैंड होते हैं, दिस इज सफिशिएंट टू गिव द रेस्पेक्ट टू द नेशनल एंथम. ओके, Now coming to the next question, which was asked in the 2003, under the Constitution of India, which one of the following is not a specific ground on which the state can place restriction on freedom of religion? इसमें से कौन सा ग्राउंड है जिसके थ्रू जो है आप फ्रीडम ऑफ रिलीजन पे कंट्रोल नहीं कर सकते हैं? फ्रीडम ऑफ रिलीजन पे ऑप्शंस विच आर पब्लिक ऑर्डर, हेल्थ, मोरालिटी एंड सोशल जस्टिस. कमेंट करके आंसर बताइए विच इज द राइट आंसर, कि जिसके आधार पे आप जो है फ्रीडम ऑफ रिलीजन को कंट्रोल या रेगुलेट नहीं कर सकते, रिस्ट्रिक्ट नहीं कर सकते. आई एम लुकिंग फॉर योर आंसर्स थ्रू द कमेंट. Yes, social justice. This is not the criteria to restrict the freedom of religion. So for that you need to refer the Article 25 Clause 1. Article 25 Clause 1 को refer करेंगे, you will get this answer. Now the next question, the proclamation of emergency used under Article 352 when Lok Sabha stand dissolved has to be approved by whom? अगर लोक सभा डिसॉल्व कर जा रहा है और आर्टिकल 352 में इमरजेंसी का प्रोक्लेमेशन है तो कैसे अप्रूव किया जा सकता है? तो what are the options? Raj Sabha and then it will continue to the reconstitution of new Lok Sabha, which must approve it within 30 days of its first sitting. Raj Sabha only, Lok Sabha in the next session after 6 months, new Lok Sabha within 6 months of its constitution. So कौन सा आंसर सही है इसमें? Just give me the answer here. Yes, this is the right answer. Raj Sabha and then it will continue till the reconstitution of new Lok Sabha, which must approve it within 30 days. And the provisions which are here, that is Article 252 Clause 4. Article 252 Clause 4 में ये आंसर है, जहाँ पे अगर लोकसभा डिसॉल्व करती है then राज्यसभा will give its approval, and then when Lok Sabha will be newly constituted, it will give its approval within the 30 days of its first sitting. Now coming to the next question, money bill can be introduced where? In either house of parliament, only in Lok Sabha, only in Raj Sabha, none of the above. Which is the right answer? कमेंट करके बताइए. बहुत ही सिंपल सा क्वेश्चन है. ए बी सी डी में कौन सा राइट आंसर है? वेटिंग फॉर योर रिस्पॉन्स. यस, द राइट आंसर इज बी. ओनली इन द लोक सभा द मनी बिल कैन बी introduced, and for that you need to refer Article 109 of the Indian Constitution. Okay, next question, which is not a qualification to become a High Court judge. He should be a citizen of India. He has at least 10 years of experience as an advocate of High Court. He has completed the age of 35 years. He has or at least 10 years held a judicial office in India. So which is the right answer? Just let me know the answer. कमेंट करके बताइए हाई कोर्ट में जज बनने के लिए क्या क्वालिफिकेशन होना चाहिए. सो यू कैन रेफर द आर्टिकल 217 here and the particular clause 2 of this where the qualification has been given. Yes, this is the age. There is no such mention. There is no such mention about the age. So it is not required. So the right answer is C. In which case the Supreme Court of India held that non-smokers cannot be compelled to be victim of air pollution. किस केस में कहा गया है कि जो स्मोकिंग नहीं करते वो विक्टिम नहीं हो सकते एयर पोल्यूशन का? एंड द ऑप्शंस विच आर गिवन, एमसी मेहता वर्सेस यूनियन ऑफ इंडिया, मुरली एस देवरा वर्सेस यूनियन ऑफ इंडिया, सतपाल डांग वर्सेस स्टेट ऑफ पंजाब, सरदारी लाल वर्सेस स्टेट ऑफ राजस्थान. कौन सा राइट आंसर है? जस्ट गिव योर आंसर थ्रू द कमेंट चैट बॉक्स. आंसर करके बताइए चैट बॉक्स कमेंट के थ्रू. यस, द राइट आंसर इज मुरली एस देवरा. दिस इज द राइट आंसर. ओके, मूविंग टू द नेक्स्ट क्वेश्चन. इन विच वन ऑफ द फॉलोइंग केस डिड द सुप्रीम कोर्ट rule that the principle of sovereign immunity will not apply to a proceeding for award of compensation for violation of fundamental right? And the options which are given here, that is G.K. Krishnan versus state of Tamil Nadu, option A. Option B, Neelbati Behra versus state of Odisha, Kasturi Lal versus state of UP, and D, state of Rajasthan versus Vidyavati. So which is the right answer? Just give me the right answer here, my friends. Yes, the right answer is Neelbati Behra versus state of Odisha. This is the right answer. Okay, so in this case, the court has held that the principle of sovereign immunity will not apply to proceeding for award of compensation for violation of फंडामेंटल राइट्स। तो अगर स्टेट ने फंडामेंटल राइट्स का वायलेशन किया है तो उनको वहां पे कंपनसेशन देना ही पड़ेगा, वहां पे सॉवरेन इम्यूनिटी का कोई क्वेश्चन नहीं उठेगा। मूविंग टू द नेक्स्ट क्वेश्चन, विच वन ऑफ द फॉलोइंग स्टेटमेंट इज इनकरेक्ट अकॉर्डिंग टू द ट्रांसफर ऑफ प्रॉपर्टी एक्ट। ऑप्शंस विच आर गिवन हियर, a transfer of property is made by the act of the parties, a transfer of property is usually made by one living person to another living person, transfer of property can be made even without writing where writing is not expressly required by law, a transfer of property can be made where transfer will operate only after the death of the transferor। सो इसमें से कौन सा स्टेटमेंट वो इनकरेक्ट है ट्रांसफर ऑफ प्रॉपर्टी एक्ट के अकॉर्डिंग। तो आंसर फटाफट कमेंट करके बताइए चैट बॉक्स में, कमेंट बॉक्स में, कि कौन सा आंसर इसमें करेक्ट है। यस, दिस इज द आंसर। अ ट्रांसफर ऑफ प्रॉपर्टी कैन बी मेड वेयर ट्रांसफर विल ऑपरेट ओनली आफ्टर द डेट ऑफ ट्रांसफर। ये इनकरेक्ट है, ऐसा ट्रांसफर नहीं हो सकता है, ट्रांसफर हमेशा लिविंग पर्सन के साथ होना चाहिए। ओके, बाकी जो स्टेटमेंट थे वो करेक्ट थे। Which of the following statement is incorrect according to the transfer of property act? इसमें से कौन सा स्टेटमेंट इनकरेक्ट है because as per the transfer of property act? Muslim women's claim for unpaid dower, right to get damage under the law of torts, claims for means profit, claims copyright of a book. So which statement is incorrect according to the transfer of property act? Give me the right answer. किसको क्लेम कर सकता है वहां पे? यस, द राइट आंसर इज हियर विच यू कैन सी, द मुस्लिम वुमेन्स क्लेम फॉर अनपेड डॉयर। दिस इज नॉट द पार्ट ऑफ दिस ट्रांसफर ऑफ प्रॉपर्टी। नाउ कम टू दिस, एन एक्शनेबल क्लेम कैन बी ट्रांसफर्ड बाय whom, बाय हाउ। क्या एक्शनेबल क्लेम को कैसे ट्रांसफर कर सकते हैं? बिकॉज बाय अ रजिस्टर्ड डॉग इंस्ट्रूमेंट, एन इंस्ट्रूमेंट इन राइटिंग साइंड बाय द ट्रांसफर, अ रजिस्टर्ड इंस्ट्रूमेंट अटेस्टेड बाय 2 विटनेस, ओरल एग्रीमेंट। किसके थ्रू आप एक्शनेबल क्लेम को ट्रांसफर कर सकते हैं? फटाफट कमेंट करके बताइए। जस्ट डू इमीडिएट कमेंट्स इन द चैट बॉक्स एंड गिव द राइट आंसर। आई एम वेटिंग फॉर योर रिस्पॉन्स। सो एक्शनेबल क्लेम को ट्रांसफर करने का तरीका क्या है? द आंसर इज एन इंस्ट्रूमेंट इन राइटिंग साइंड बाय द ट्रांसफर। सो दिस इज द राइट आंसर, so that you can transfer the actionable claim. Okay, the answer is B. Okay, moving to the next question. So moving to the next question, law favors vesting of and disfavor the divesting of interest is clear from the provisions contained in the following sections. किस सेक्शन के थ्रू आप टीपीए के किस सेक्शन के थ्रू इट इज देयर दैट लॉ फेवर्स वेस्टिंग एंड डिसफेवर दिस डाइवेस्टिंग ऑफ इंटरेस्ट? सो फटाफट कमेंट करें, जस्ट पुट योर कमेंट्स इन द कमेंट बॉक्स एंड give your right answer which would find that it is right answer. Yes, this is the right answer, section 28 and 29. Okay, moving towards the next question, fraudulent transfer has been defined under which section of the transfer of property act? whether section 19, 21, 53, 35, किस सेक्शन में डिफाइन किया गया है फ्रॉडुलेंट ट्रांसफर को टीपीए के? आंसर फटाफट कमेंट करके बताइए किस में कहा गया है फ्रॉडुलेंट ट्रांसफर। यस, राइट आंसर इज सेक्शन 53। दिस इज द राइट आंसर बिकॉज सेक्शन 35 is a different provision, 21 is also different, and 19 is different. So the answer is section 53 of the TPA. Now moving to the next question, which of the following interest is not transferable? इसमें से कौन सा इंटरेस्ट है जो ट्रांसफरेबल नहीं है? वेस्टेड इंटरेस्ट, कॉन्टिजेंट इंटरेस्ट, स्पेस सक्सेशन, इंटरेस्ट ऑफ लेजी। कौन सा आंसर है? करेक्ट करके बताइए आप इसमें कमेंट करके चैट बॉक्स में कमेंट कीजिए और राइट आंसर बताइए। क्या वेस्टेड इंटरेस्ट है या फिर कॉन्टिजेंट इंटरेस्ट है? कौन सा है? Yes, the answer is space successions. This is the section 6A of the TPA where you can get the answer. So space succession is not transferable. Now next is, for creating an interest in favor of an unborn person, which of the following is essential? एक अनबॉर्न पर्सन के में ट्रांसफर ऑफ प्रॉपर्टी क्रिएट करने के लिए कौन सा कंडीशन जरूरी है, एसेंशियल जरूरी है? Options which are given here: creation of a prior life interest in favor of living person, unborn person must be born before the termination of last prior life interest, absolute interest is to be given to the unborn person, and D all of the above. कौन सा राइट आंसर है? जल्दी से फटाफट कमेंट करके बताइए. गिव योर आंसर्स थ्रू द कमेंट्स. वेटिंग फॉर योर रिस्पॉन्स. कौन सा है इसमें से राइट आंसर? विच इज द राइट आंसर? यस, द राइट आंसर इज डी, फॉर क्रिएटिंग an interest in favor of unborn child or unborn person, all these three conditions must be fulfilled. Okay, or a sale, here is a illustration which I am going to take here. A sells his house to B with the condition that B cannot transfer his house to anyone except C, whether the sale is valid, but condition is void, unlawful, voidable. कौन सा कंडीशन, कौन सा आंसर सही होगा? कमेंट करके बताइए. ए सेल्स हिज हाउस टू बी विद अ कंडीशन दैट बी कांट ट्रांसफर हिज हाउस टू एनीवन एक्सेप्ट सी. द सेल इज, whether sale is valid but the condition is void, or whether the sale is void itself, whether sale is unlawful itself, whether sale is voidable itself. Which is the right answer? Yes, right answer is valid. The sale is valid but the condition is going to be void, because whenever the transfer of property is going to take place or sale is going to take place, it must be of absolute in character. Now coming to the next question. A makes a gift of rupees 50,000 to B. A reserves right with B's consent to take back at pleasure rupees 10,000 out of rupees 50,000. So whether this gift is void. So A makes a gift to B कि 50,000 रुपये का गिफ्ट करते हैं B को, मगर एक राइट भी रखता है A कि जो है बी कंसेंट से वो 10,000 रुपये वापस ले सकता है फ्रॉम द 50,000 रुपीज़. क्या ये गिफ्ट सही है? सो वेदर द गिफ्ट इज वायर्ड, गिफ्ट इज वैलिड अप टू रुपीज़ 40,000 एंड वायर्ड इज टू टेकिंग बैक ऑफ रुपीज़ 10,000, गिफ्ट इज वाइडेबल. विच इज द राइट आंसर? कमेंट करके बताएं. यस, द राइट आंसर इज सी. The gift is valid only up to rupees 40,000 and taking back of rupees 10,000 is void. This is not a kind of a gift, because in gift you have to give absolute transfer. Okay. A universal donee is liable to the creditors of the donor. The liability of the universal donee is. Now, a universal donee is liable to the creditors of the donor, and the liability of the universal donee is whether it would be a personal one to the extent of value of the gifted property is his hands based on pious obligation limited to a reasonable amount. So which is the right answer? Give your answer in the comment box. Waiting for a response. फटाफट आंसर करें. Yes, the answer is to the extent of the value of the gifted property is his hand. So this is the right answer. Now coming to the next question. Which of the following provision of the CRPC is not related to appeal? इसमें से कौन सा प्रोविजन है CRPC का जो अपील से रिलेट नहीं करता है? सेक्शन 86, सेक्शन 449, सेक्शन 450, सेक्शन 454. विच इज द राइट आंसर हियर? फटाफट कमेंट करके बताएं. यस, दिस इज द सेक्शन 450 which do not relate to the appeal. Rest of the things are relating to the appeal directly or indirectly. 86 relate to the appeal with respect to the restoration of attached property. Section 449 relates to the appeal from orders under section 446. Section 454 it relates appeal to against order under section 452. So rest of the things, rest of the sections are relating, having some provision with respect to appeal, except the section 450. This provision do not relate to the appeal. Okay, so now moving to the next question. In the absence of contract or local law or user to contrary, a lease of immovable property for manufacturing purpose shall be deemed to be for 5 years, from year to year, from month to month, for a reasonable period. अगर कोई कॉन्ट्रैक्ट नहीं है, कोई लोकल लॉ नहीं है और यूजर टू कॉन्ट्रेरी कोई लीज और इम्यूवेबल प्रॉपर्टी होती है फॉर मैन्युफैक्चरिंग, तो वो वहाँ पे जो लीज होगा वो कैसे माना जाएगा? सो व्हाट इज द आंसर? क्या वो साल, इट विल बी अंडरस्टूड दैट इट इज फॉर ईयर टू ईयर और 5 years, मंथ टू मंथ? फटाफट गिव यू आंसर थ्रू द कमेंट्स इन द चैट बॉक्स, आंसर कीजिए, लुकिंग फॉर योर रिस्पॉन्स। ये काफ़ी इंपॉर्टेंट क्वेश्चन है। ऑल दिस क्वेश्चन दे मे बी again asked in the UP prelims. Yes, the right answer is they would be from year to year. For that you can refer this section 106. Section 106 of the TPA, where you can find this kind of the answer. Which of the following is ground for determination of a lease by forfeiture? Which of the following is a ground for determination of lease by forfeiture? Options which are given here: on breach of express condition, on expiry of lease period, on surrender by lease, on vesting of lesser's interest in the lessees. कौन सा राइट आंसर है? जस्ट गिव मी द आंसर थ्रू द कमेंट्स. विच इज द ग्राउंड टू डिटर्मिनेशन ऑफ लीज, यानी कि लीज जो है लीज को समाप्त करने का कौन सा तरीका है यहाँ पे फोरफीचर के थ्रू? आंसर फटाफट कमेंट करके बताइए. यस, द आंसर इज दिस वन, दैट इज द ऑन ब्रीच ऑफ एक्सप्रेस कंडीशन. ओके, मूविंग टू द नेक्स्ट क्वेश्चन. दिस इज मैचिंग लिस्ट. So we have to see which are the select, we have to correct the select matching here. Holding over, mortgage, universal donee, gift, redemption, lease, purchaser, sale, इसमें से कौन किससे के साथ मैच करता है, ये आंसर हमको यहाँ पे बताना होगा. फटाफट आप मैच करके बताइए इसमें से कौन सा ये जो है सही है. फटाफट बताइए इसमें से ए बी सी डी में से कौन सा सही है. फटाफट करके बताइए आंसर. थोड़ा I am giving little bit time to you to read this one. फटाफट आंसर करके बताइए भाई. ओके, द राइट आंसर इज हियर, दैट इज द ए. होल्डिंग ओवर बिलोंग्स टू लीज, universal donee belongs to gift, redemption belongs to the mortgage, and purchaser belongs to the sale. So this is the right answer. Okay, coming to the assertion and reason. Legal incidents, this is assertion. Legal incidents of a gift includes absolute enjoyment of the gift. Now reason, the donee cannot be restrained in his enjoyment of gift by any condition. Okay, so assertion has been given and reason has been given. So the code which are given, we have to find the correct code here. Both A and R true, and R is the correct explanation of A. Both A and R true, but R is not the correct explanation of A. A is true, but R is false. A is false, but R is true. Which is the right answer? Just let me know the answer here. फटाफट कमेंट करके बताइए. Yes, the right answer is A, because जब भी आप गिफ्ट ट्रांसफ़र करते हैं आप हमेशा उसको एब्सोल्यूट ट्रांसफ़र करते हैं, कभी भी रिस्ट्रिक्ट नहीं करते हैं, कोई कंडीशन इम्पोज नहीं करते हैं. नाउ कमिंग टू द नेक्स्ट क्वेश्चन. विच स्टेटमेंट इज नॉट करेक्ट अबाउट द मॉर्गेज? नंबर 1, इट इज अ ट्रांसफर ऑफ इंटरेस्ट इन स्पेसिफिक इमूवेबल प्रॉपर्टी. देन द अनदर ऑप्शन विच इज गिवन हियर, दैट इज देयर इज अ ट्रांसफर ऑफ ओनरशिप इन मॉर्गेज. The another option which is given here, consideration is an essential element in mortgage. There are 6 types of mortgage in Transfer of Property Act 1882. So now we have to see that which is not the correct about the mortgage. इसमें से कौन सा करेक्ट नहीं है? क्या ये करेक्ट नहीं है? It is transfer of interest in specific immovable property. There is a transfer of ownership in the mortgage. Now whether the consideration is an essential element in mortgage. There are 6 types of the mortgage. कौन सा सही है? Give the answer. Yes, the right answer is the mortgage is never a transfer of ownership. Okay, so therefore this is the right answer. Which one of the following is not generally an essential elements of crime? इसमें से crime का कौन सा element नहीं होता है? Actus reus, motive, mens rea, human beings. So which is the not an essential element of crime? फटाफट आंसर करें. Very easy question. Yes, the answer is motive. Which one of the following cases is not related to criminal attempt? The options are Abhinand Mishra versus State of Bihar, Sudhir Kumar Mukherjee versus State of Bihar, West Bengal, State of Maharashtra versus Mohammad Yaqub, State of Rajasthan versus ओम प्रकाश. इसमें से कौन सा केस जो है वो क्रिमिनल अटैम्प्ट से बिलोंग नहीं करता? फटाफट कमेंट करके आंसर बताइए. लुकिंग फॉर योर आंसर्स. फटाफट कमेंट करें. Yes, the answer is D. State of Rajasthan versus Om Prakash. This belongs to section 36 of the IPC. Okay, therefore this is not the right answer. Now the next question. The case of R versus Dudley and Stephen is related to the defense of which one? Insanity, intoxication, mistake of fact, necessity. किससे ये बिलोंग करता है आर वर्सेस डडले एंड स्टेफन का केस? फटाफट ऑप्शन करें. बहुत इजी क्वेश्चन, बहुत इंपॉर्टेंट क्वेश्चन, कई बार आता है एग्जाम में, आ चुका है. यस, दिस बिलोंग्स टू नेसेसिटी. दिस बिलोंग्स टू नेसेसिटी. यू आर राइट. नाउ द नेक्स्ट क्वेश्चन इज विच ऑफ द फॉलोइंग कॉम्बिनेशंस आर नॉट करेक्टली मैच्ड? इसमें से कौन सा करेक्टली मैच्ड नहीं है? सिराज वर्सेस डी रुडजन, बारिंदर कुमार घोष वर्सेस इम्परर, अभयानंद मिश्रा वर्सेस स्टेट ऑफ बिहार, ज्ञान कौर वर्सेस स्टेट ऑफ पंजाब. इसमें से कौन सा सही से मैच नहीं कर रहा है? फटाफट आंसर करें. यस, ओनली दिस इज हैज अ करेक्ट मैच. Siraj versus D. Rudjan. Rest of they are not correctly matched. Okay. Abhinand belongs to criminal attempt. Bharan Kumar Ghosh belongs to the the case which belongs to the conspiracy and all this, and the Gyan Kaur belongs to the commit to suicide. Okay. Now coming to this question, next assertion: nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act. So this question is on section 84 of the Indian Penal Code. Mistake of fact is good defense and mistake is no defense. Okay, mistake of law is no defense. Okay, so now which is the right answer? So just go to the statement again. Nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act. And reason is mistake of fact is a defense and mistake of law is no defense. So whether both and A are true and R is the correct explanation of A, both A and R are true but R is not the correct explanation of A is true but R is false, A is false but R is true. इसमें से करेक्ट आंसर कौन सा है? फटाफट कमेंट करके बताइए. Yes, this is the both statements are correct, but it is not giving the right reason for the section 84 of the IPC. So therefore, this is the right answer. Now coming to the next question, the right of private defense of property extend to causing of death when the offense apprehended is. कब right of private defense जो है प्रॉपर्टी में डेथ कॉज करने के लिए अलाउ करता है? कब? Whether it is in case of theft, house trespass, mischief and डकैती, किसमें अलाउ करता है? फटाफट कमेंट करके बताइए. Yes, the answer is डकैती. Which one of the following is not essential element of section 34 of the Indian Penal Code? 34 का essential element नहीं है, जो कि section 34 of the IPC का essential element नहीं है. Options are criminal act done by several person, criminal act done in furtherance of common intention, pre-arranged plan between persons doing criminal act done in furtherance of common object. इसमें से राइट ऑप्शन कौन सा है जो कि इसेंशियल नहीं है सेक्शन 34 का? फटाफट कमेंट करके बताइए. So you all know that section 34 belongs to common intention and therefore it will not in the furtherance of common object. तो ये जो है ये इसका राइट जो है यहाँ पे आंसर यही होगा कि ये इसेंशियल एलिमेंट नहीं है. Which one of the following is not a valuable security? A postal receipt for an insecure parcel, a rent note, a promissory note, a deed of divorce. Which is not a valuable security? Just give the answer. Yes, Just giving clue, section 30 of the IPC will help you here. बताइए फटाफट आंसर करके. Yes, a deed of divorce is not a valuable security. Coming to the next question. A in India instigate B, a foreigner in Pakistan, to commit a murder in Pakistan. B commits murder. In this case, A is guilty of abetting murder. A is not guilty of any offense. A is liable for committing murder. And D, none of the above is correct. कौन सा आंसर सही है फटाफट करके बताइए. Yes, the answer is he is abating the murder, because murder is not taking place in Pakistan, so he will be only guilty for the abating the murder, and the answer is section 108A of the IPC. Okay, just refer this section. Okay, J is a price, beats a boy for curing him from evil spirit. The boy dies. J is whether he will be not liable for any offense, liable for culpable homicide, entitled to the defense of good faith, liable for attempt to murder. Which is the right answer? Just come and do फटाफट करके बताइए. Whether he will be liable? Yes, he will be liable for culpable homicide. Now coming to the next question, disclosure of the identity of a victim of rape is punishable under which section of the IPC? The section 376 of IPC, section 229 of the IPC, or section 228 of the IPC, or section 228A of the IPC. My dear friend, this is very important question. It is being asked in all the judicial examinations of every states. Give the right answer in your comment box. फटाफट बताइए कौन सा आंसर सही है. Yes, the right answer is section 228A of the IPC. Section 228A of the IPC. Next question, use of violence by a member of an assembly of 5 or more persons in furtherance of common object will constitute, whether it will constitute affray, assault, rioting, unlawful assembly. Which kind of the offense it will constitute? Just give the answer immediately through the chat box, through the comments, please. कौन सा ऑफेंस होगा जब 5 या 5 से ज़्यादा लोग मिलके एक कॉमन ऑब्जेक्ट के लिए जो है वायलेंस करते हैं. Yes, the answer is rioting. A, having lost the receipt for debt which he has paid to B, make out another receipt himself, and when B sues him puts up the made up receipt in evidence. In this case, A is guilty of the offense of forgery. A is guilty of no offense. A is guilty of cheating. None of the above answer is correct. Which is the right answer here? Yes, the right answer is A is guilty of the offense of forgery. Okay. Now moving to the next question. A, intending to commit theft, enters the house of B at night and removes from one of the rooms a box to the courtyard where he opens it. He does not find in the box anything worth taking and leaving the box there goes away. In this case, which kind of the offense he has committed? Okay, तो वो इंटर करता है, फिर वहाँ से वो बॉक्स को हटाता है, लेकिन कुछ नहीं पाता है बॉक्स को, और बॉक्स को वहीं छोड़ के चला जाता है. तो वहाँ पे कौन सा ऑफेंस उसने किया? सो जस्ट गिव द आंसर. यस, A is liable only for house trespass. A is liable for theft. A has committed no offense. A is liable for house trespass and attempt to commit theft. कौन सा आंसर सही है इसमें से? फटाफट गिव योर आंसर थ्रू द कमेंट एंड चैट बॉक्स. आई एम वेटिंग फॉर द रिस्पॉन्स. फटाफट आंसर करें. Yes, the right answer is D, because in this case both offenses was committed, house trespass and offense to commit theft. जैसे उसने वहाँ से डिस्प्लेस किया, वो जो है ऑफेंस ऑफ थेफ्ट भी हो गया, अटेम्प्ट टू ऑफेंस ऑफ थेफ्ट. A house owner tortures his tenant B in order to compel him to pay his rent and realize his dues without causing any hurt to B. Here, A is liable for criminal intimidation under section 503 of the IPC. A is liable for using criminal force under section 350 of the IPC. A is liable for extortion under section 383 of the IPC. is liable for assault under section 351 of the IPC. So which kind of the offense is going to be committed here? फटाफट आंसर बताएं. प्लीज गिव योर आंसर थ्रू द कमेंट्स. कमेंट बॉक्स, चैट बॉक्स से कमेंट करके बताएं. Yes, A is liable for criminal intimidation under section 503 of the IPC. Okay, so he has compelled him that if he will not do, he will cause a hurt. Okay, so therefore it would be a case of criminal intimidation. Which one of the following combinations are not correctly matched? Okay, so we will see which is not correctly matched here. Dowry there, section 498A, rape, section 377, adultery 497, robbery 391. So which is not correctly matched here? Okay, now let's see here the options which are given here. Okay, the 1 2 4 1 2 1 3 4 1 2 4 1 2 3 the 2 3 4. So which is not the correctly matched. Okay, so just see this, which is the not correctly matched. So which one is not correct? So dowry debt is not correctly matched here. Adultery is correctly matched. Rape is not here, 77. Robbery is not in 391. So the answer is, which is not correctly matched. The one is 1, dowry death. The second is rape, and that is 2. And the fourth is dowry. So 1 to 4. Okay. So now let's see the answer here. Yes, the B is the right answer. Okay. Now moving to the next question. Again, it is from the IPC. A was on his journey by car from Allahabad to Lucknow. B met him in the way and requested for a lift up to Raebareli, an intermediate town. A agreed to his request, but on reaching Raebareli, he did not drop B there. In spite of his repeated request, B was carried over to Lucknow against his wishes. Here, whether A is guilty of kidnapping B, A is committed no offense, A is guilty of wrongfully confining B, A is guilty of abducting. फटाफट कमेंट करें, बहुत ही इस तरह के इलस्ट्रेशन आते हैं एग्जाम में भी. तो फटाफट बताइए कौन सा आंसर सही है. यहाँ पे कमेंट करके बताएं. आई एम वेटिंग फॉर रिस्पॉन्स. क्या ये अबडक्शन का केस होगा, रॉन्गफुली कन्फाइनिंग का केस होगा, किडनैपिंग का होगा, या कोई ऑफेंस ही नहीं होगा? यहाँ पे फटाफट कमेंट करके बताएं. रास्ते में जा रहा, इलाहाबाद से वो लखनऊ जा रहा थे, रास्ते में बी मिला. बी ने उससे रिक्वेस्ट किया कि भाई रायबरेली मुझे छोड़ देना, क्योंकि इलाहाबाद से लखनऊ के बीच में रायबरेली आता है. रायबरेली आया, मगर उसने बिल्कुल रोका नहीं, बल्कि वो बार बार रिक्वेस्ट करता रहा भी कि मुझे छोड़ दो छोड़ दो. वो लखनऊ जाके उसको छोड़ा. तो ये क्या कन्फाइनमेंट होगा रॉन्गफुल, या फिर किडनैपिंग होगा, अबडक्शन होगा? यस, फटाफट बताइए. यस, द आंसर इज A is guilty of wrongfully confining B. Okay, so this is the right answer, which is here. Okay, coming to this, for that you can also refer section 340 of the IPC, in which case the right of private defense of body does not extend to causing of death. किस केसेस में right to private defense जो है of body will not extend to cause the death? The options which are given: an assault with intention to wrongfully restraining a person, with an assault with intention to committing rape, an assault with the intention of kidnapping, an assault with the intention of gratifying unnatural lust. तो कौन सा आंसर होगा? फटाफट कमेंट करके बताएं. कमेंट करें भाई, ज़्यादा जल्दी जल्दी, आपके एग्जाम भी बहुत करीब है, फटाफट करें इसको. यस, द आंसर इज wrongfully restraining a person, an assault with the intention of wrongfully restraining a person. In this case, the person will not have a right to cause the death in the name of the private defense of the body. Moving to the next question, which of the following combination is correctly matched? इसमें से कौन सा कॉम्बिनेशन करेक्टली मैच्ड है? फटाफट देखते हैं और पता करते हैं कौन सा करेक्टली मैच है, कौन सा करेक्टली मैच नहीं है. सो ऑप्शन विच आर हियर: इनवॉलंटरी इंटॉक्सिकेशन सेक्शन 86, वासुदेव वर्सेस स्टेट ऑफ पेप्सू 86, अटेम्प्ट टू कमिट सुसाइड 306, बाइगेमी इज 497. इसमें से फटाफट कर बताइए कि कौन सा कॉम्बिनेशन जो है वो करेक्टली मैच्ड है. फटाफट कमेंट्स करें. यस, द आंसर इज वासुदेव वर्सेस स्टेट ऑफ पेप्सू. This case belongs to the section 86 of the IPC. Now coming to the questions from the contract here. Okay, a proposal when accepted becomes, जब प्रपोजल को आप एक्सेप्ट कर लेते हैं तो वो क्या बन जाता है? क्या वो प्रॉमिस बन जाता है, इट कॉन्ट्रैक्ट्स, एन एग्रीमेंट और नन ऑफ द वेब? फटाफट कमेंट करके बताएं इमीडिएटली. इट विल नॉट टेक मच टाइम बिकॉज द क्वेश्चन इज वेरी इजी एंड इट स्टार्ट फ्रॉम सेक्शन 2 ऑफ द इंडियन कॉन्ट्रैक्ट एक्ट. यस, इट बिकम्स अ प्रॉमिस. विच ऑफ द फॉलोइंग इज अ वैलिड एक्सेप्टेंस ऑफ प्रपोजल? इसमें से एक्सेप्टेंस ऑफ प्रपोजल का कौन सा सही तरीका है? ओके, कौन सा वैलिड एक्सेप्टेंस है? व्हेन एन एक्सेप्टेंस इज मेड इन इग्नोरेंस ऑफ प्रपोजल, जब आपने एक्सेप्टेंस किया लेकिन आपको प्रपोजल ही नहीं पता है. व्हेन एन एक्सेप्टेंस इज मेड इन यूजुअल एंड रीजनेबल मैनर बट नॉट इन अ मैनर प्रेस्क्राइब्ड बाय द प्रोसीजर प्रपोजर, जब आपने एक्सेप्टेंस तो किया है यूजुअल और रीजनेबल तरीके से, लेकिन जिस प्रकार से प्रपोजर ने प्रेस्क्राइब किया वो जो है उस तरीके से नहीं किया. द थर्ड वन इज व्हेन एन एक्सेप्टेंस इज मेड इन अ मैनर प्रेस्क्राइब्ड बाय द प्रोपोजर, जब वो प्रपोजर के बताए हुए तरीके से किया जाता है. डी, नन ऑफ द एबव. फटाफट आंसर करके बताएं कौन सा आंसर सही है यहाँ पे. कमेंट करें. यस, द आंसर इज विच वन? बी या फिर सी? फटाफट करके बताएं. यस, द आंसर इज सी. जब आपने प्रपोजर के बताए हुए तरीके से ही एक्सेप्टेंस किया है तो वो वैलिड एक्सेप्टेंस का पार्ट होगा. एन एग्रीमेंट मेड विदाउट फ्री कंसेंट इज, whether it would be always void, voidable, unlawful, either void और voidable. क्या होगा जब आप एग्रीमेंट करते हैं विदाउट फ्री कंसेंट? क्या voidable होगा और या अनलॉफुल होगा या ऑलवेज वाइड ही होगा? फटाफट कमेंट करके बताएं. यस, द आंसर इज voidable. अंडर सेक्शन 19 ऑफ द इंडियन कॉन्ट्रैक्ट एक्ट इट वुड बी voidable and it can be declared void as per the instance of the person who has given the consent. Moving to the next question. A contract through telephone is considered concluded at the place where acceptance is heard. In which of the following case it was held? अगर आप टेलीफोन के थ्रू एक्सेप्टेंस करते हैं तो वो वहीं पे माना जाएगा एक्सेप्ट हुआ जहाँ पे एक्सेप्टेंस सुना गया है. ओके, सो विच केस? whether the case of भगवान दास गिरधारी लाल कालिल वर्सेस कार्बोलिक स्मोक बाल कंपनी, लालमन शुक्ला वर्सेस गौरी दत्त, सत्यव्रत घोष वर्सेस मुगनी राम. कौन सा केस है? बहुत इंपॉर्टेंट केस है. फटाफट कमेंट करके बताएं. गिव योर आंसर्स थ्रू द कमेंट बॉक्स इमीडिएटली. वेटिंग फॉर योर रिस्पॉन्स. कौन सा होगा भाई? भगवान दास कार्लिल वर्सेस कार्बोलिक स्मोक, लालमन शुक्ला. मैं आपको बता दूं, जस्ट आई वांट टू गिव एन इन्फॉर्मेशन दैट देयर इज वन वीडियो ऑन द Carlyle versus Carbolic Smoke Ball Company. So if you want to refer that judgment, you can go to my YouTube channel. You can find the case from here. Okay, so the answer is Bhagwan Das versus Girdhari Lal. Okay, moving to the next question. Which of the following case is related to the doctrine of frustration? Which case belongs to doctrine of frustration? Hadley versus Baxendal, Carlyle versus Carbolic Smoke Ball Company, Satyabrat Ghosh versus Mugni Ram, State Bank of India versus Quality Bread Factory. Which case belongs to doctrine of frustration? फटाफट कमेंट करके बताएं. Immediately give your response to the chat box. Quick, fast, do post your comments quickly in the comment box. Waiting for your response. Yes, the right answer is here. Which one? Whether Hadley versus Baxendale और Carlyle versus Carbolic. कौन सा right answer है? Yes, the right answer is Satyabrat Ghosh versus Mugni Ram. This is the right answer. This case belongs to the doctrine of frustration. Coming to the next question. Which one of the following case is not related to the damages for breach of contract? So options which are given here again: Headley versus Banksdale, State of Rajasthan versus Novelty Stores, Madras Railway Company versus Govind Rao, Domination of India versus All India Reporters Limited. Just give your response quickly in the chat box. फटाफट आंसर करें. आई एम वेटिंग फॉर योर रिस्पॉन्स. फटाफट रिस्पॉन्स करें आप सब लोग. विच इज द राइट आंसर? यस, द राइट आंसर इज स्टेट ऑफ राजस्थान वर्सेस नोवेल्टी स्टोर्स, विच डू नॉट बिलोंग टू द केस ऑफ ब्रीच ऑफ डैमेज. बाकी जितने केसेस हैं, रेस्ट ऑफ द केसेस बिलोंग्स टू द ब्रीच ऑफ contract. So this is how you can also remember all these cases. Now coming to the question which is based on assertion and reason. Now assertion is here, all illegal agreements are void, but all void agreements are not illegal. Reasons which are given here, only those agreements of which of the object or consideration is unlawful are known as illegal agreements. So this is the reason which has been given here. Okay, now just read the assertion and reason by your own. I am zooming it and just read very carefully. Again, I am reading for all of you here. All illegal agreements are void, but all void agreements are not illegal. Only those agreements of which of the object consideration is which of the object or consideration is unlawful are known as illegal agreements. Okay, so now whether both A and R correct are true and R is the correct explanation of A, both A and R are true but R is not the correct explanation of A. Now moving to the next, A is true but R is false, A is false but R is true. Which is the right answer? फटाफट आंसर कमेंट करके बताएं. Yes, the answer is right is here A. Both A and R are true, but R is the correct explanation of, and R is the correct explanation of A. So this is the right answer. Okay. Coming to the next question, which of the following agreement is not void? So A agrees to sell 200 tons of oil to B. An agreement in restraint of legal proceedings. An agreement if restraint of marriage of any person. A finds B's purse and give it to him. B promises to give A rupees 100. इसमें से कौन सा एग्रीमेंट जो है वो वायड नहीं है? फटाफट कमेंट करके बताइए चैट बॉक्स में, कमेंट बॉक्स में. गिव योर रिस्पॉन्स क्विकली, वेटिंग फॉर योर रिस्पॉन्स. यस, दिस इज द राइट आंसर. A finds B's purse and gives it to him. B promises to give A rupees 100. This is not a void agreement. It is agreement is not void here, and therefore this is how you can find. But in the rest of the cases, जहाँ आप मैरिज में प्रोसीडिंग में आप रेस्ट्रेन करते हैं या किसी के लीगल प्रोसीडिंग में आप प्रॉब्लम क्रिएट करते हैं, जहाँ आपको पता ही नहीं है कि किस प्रकार का ऑयल बेचना है, वो सब जो है एग्रीमेंट वाइड होंगे. कमिंग टू द नेक्स्ट क्वेश्चन of the Indian Contract Act. Matching list first and list 2 and select correct answer using codes given the list. Okay, so we have to go with the matching. Novation, unjust enrichment, party competent to contract, disposition of property induced by threat to cause death. So फटाफट देखिए कौन सा सेक्शन दिया गया. सेक्शन 70, सेक्शन 62, सेक्शन 11, सेक्शन 15. फटाफट बताइए इसमें से कौन सा आंसर सही है, कौन सा मैचिंग सही है. यहाँ पे कमेंट करें प्लीज. डू योर कमेंट क्विकली ऑन इन द कमेंट बॉक्स. वेटिंग फॉर योर रिस्पॉन्स हियर, वेटिंग फॉर योर रिस्पॉन्स हियर. यस, द आंसर इज हियर ए बी सी डी. इसमें कौन सा करेक्ट है फटाफट बताइए. ओके, आंसर इज ए इज करेक्ट. ओके, सो नोवेशन बिलोंग्स टू सेक्शन 62. अनजस्ट इन्वेस्टमेंट बिलोंग्स टू द सेक्शन 70. Party competent to contract belongs to the section 11, and disposition of property induced by threat to cause death section 15. Okay, so this is the way you can find the matching correct here. Okay, so the A is correct answer. Now the next question, a contingent contract dependent on the happening of future uncertain event can be enforced when the event happens, becomes impossible, does not happen, and the last option none of the above is correct. Which is the right answer? फटाफट कमेंट करके बताएं. जस्ट सेंड योर आंसर्स इन द कमेंट बॉक्स क्विकली, फास्ट. So on future uncertain events, when this event happens, then in that case you can enforce this contract here. Enforce contract here. For that you can refer to section 32 of the Indian Contract Act. Okay, now when prior to the due date of performance the promisor absolutely refuses to perform the contract, it is known as abandonment of contract, actual breach of contract, remission of contract, anticipatory breach of contract. So which is the kind of the answer is given here? फटाफट बताइए. ड्यू डेट परफॉर्मेंस है, उससे पहले ही उसको रिफ्यूज़ कर दिया गया, वो कौन सा होगा? बताइए फटाफट. Yes, the answer is anticipatory breach of contract. For that, you can refer the section here, section 39 of the Indian Contract Act here. Moving to the next question. When the agent construct without disclosing name and existence of his principals, in such case, on knowing about the principal, the third party may file a suit against principal alone, agent alone, either agent or principal both, none of the above. कौन सा आंसर सही होगा? जब प्रिंसिपल को जानता ही नहीं था, केवल एजेंट के थ्रू आया, और जब प्रिंसिपल पता नहीं कि प्रिंसिपल कौन है, तो अगर वो कॉन्ट्रैक्ट को तोड़ना चाहेगा तो किसके थ्रू करेगा, कैसे करेगा? फटाफट आंसर कमेंट करके बताएं. Yes, in this case he can suit against both agent as well as principal. Okay. Now moving to the next question. Age indebted to B, he authorizes B to sell his house and to pay himself out of sale proceeds the debts due to him in the absence of express contract. Okay. So whether in this case what will happen? Whether A can revoke the agency, A cannot revoke the agency. Agency is not terminated by A's death. Both B and C are correct. फटाफट आंसर करके बताएं क्या होगा. Yes, A can't revoke the agency as well as the agency is not going terminated by the date of A's. So therefore the answer is D here. Now moving to the next question. Placed by a seller in possession of goods after sale is whether it would be valid, void, voidable और unlawful. क्या होगा इसमें से? फटाफट बताइए आप लोग कमेंट करके. गिव यू रिस्पॉन्स टू द कमेंट बॉक्स. Placed by a seller in possession of goods after sale is. Yes, it would be a valid one. A hires a carriage of B. The carriage is unsafe. B is not aware of fruits in carriage. A is injured. Whether B is liable. A ने B का कैरेज हायर किया और जो कैरेज अनसेफ था, लेकिन B को उसके बारे में कोई जानकारी नहीं था, तो और A को लॉस हो जाता है. और उसमें क्या होता है, क्या लाइबिलिटी आएगी फॉल्ट की वजह से? B इज़ नॉट अवेयर ऑफ फॉल्ट्स इन कैरेज, तो क्या लाइबिलिटी बनती है वहाँ पे? Yes, B is going to be liable here. A guarantees which the creditor has obtained by means of keeping silence as to a material circumstances. A guarantee which the creditor has obtained by means of keeping silence. जहाँ पे कीप साइलेंस था और जो इंफॉर्मेशन चाहिए तो उसके बारे में वो साइलेंस था, क्या वहाँ पे वो सही है या गलत होगा? वैलिड होगा, इनवैलिड होगा, वाइडेबल होगा, क्या होगा वहाँ पे? फटाफट कमेंट करके बताएं. ए ने गारंटी विच द क्रेडिटर हैज ऑब्टेन बाय मींस ऑफ कीपिंग साइलेंस, तो क्या होगा यहाँ पे? वैलिड होगा, वाइडेबल होगा, इनवैलिड होगा, क्या होगा? फटाफट कमेंट करके बताएं. गिव योर रिस्पॉन्स टू कमेंट बॉक्स. गिव आंसर क्विकली. यस, इट इज गोइंग टू बी इनवैलिड वन. Coming to the next question. Which of the following section of Indian Contract Act embodies the rule of Clanton's case relating to appropriation of payments? Indian Contract Act में कौन सा रूल है, कौन सा सेक्शन है जो क्लैंटन्स केस से रिलेटेड है, जो पॉपुलर इंग्लिश केस है उससे रिलेटेड माना जाता है? सेक्शन 59, सेक्शन 61, 60, 60, 58. फटाफट कमेंट करके बताएं. क्रेडिटर केस में जो होता है अप्रोप्रिएशन ऑफ पेमेंट्स की बात होती है. कैसे पेमेंट्स का बंटवारा होगा उसके रिगार्डिंग है. यस, द आंसर इज सेक्शन 59 ऑफ द इंडियन कॉन्ट्रैक्ट एक्ट. मूविंग टू नेक्स्ट क्वेश्चन. द रूल इनिशिएटेड बाय सेक्शन 65 ऑफ द इंडियन कॉन्ट्रैक्ट एक्ट 1872 is applicable to agreement which are reduced void by mistake, failure of consideration, impossibility of performance of contract, और डी ऑल ऑफ द above. फटाफट बताएं कब ये जो है एग्रीमेंट जो है वो वाइड हो जाएगा, किन कारणों से. गिव योर आंसर क्विकली इन द कमेंट बॉक्स, in the chat box. Yes, the answer is impossibility of performance of contract. This is the right answer here. Moving to the next question, which is based on the assertion and reason. Assertion is here, minus contract is void. Mortgage executed in favor of a minor is enforceable by him. So now the options which are given here, both A and R true, but R is the correct explanation of A. Both A and R are true, but R is not the correct explanation of A. C, A is true, but R is false. A is false, but R is true. इसमें से कौन सा करेक्ट आंसर है, फटाफट कमेंट करके बताएं चैट बॉक्स में. आई एम लुकिंग फॉर योर आंसर्स. फटाफट डू योर आंसर्स, सबमिट योर आंसर क्विकली. Yes, both are correct, that are true, but R is not the correct explanation. Okay, so it is not the correct explanation because both are different kinds of the talk. That is, one is context, second is about the mortgage. Coming to the next question, which is belonging to international law. Which of the following is not a purpose of United Nations under Article 1 of the Charter? Please, my dear friends, you all need to read Article 1 of the UN Charter very carefully, because often you will find one or two questions from the UN Charter, particularly Article 1 of the United Nations. Okay. Now, to achieve international cooperation in solving international problems of social character, to bring about adjustment of international dispute by peaceful means, to develop friendly relations among nations, to ensure democratic government and the rule of law in the states of the world. Which is the right answer? फटाफट कमेंट करके बताएं. Give your answers in the chat box. Response quickly. Waiting for your response here. I am zooming in so that you can read the question very easily here. So which is not the purpose? Yes, the answer is D, to ensure democratic government and rule of law. This is not the object of the Article 1 of the United Charter. Which of the following combinations are correctly matched? Okay, let's see. Permanent Court of Arbitration, number of is 7. ICC, International Criminal Court, 15. International Tribunal of the Law of Sea, 21. UN War Crimes Tribunal for Yugoslavia, 15. These numbers may be changed. This number may be updated one. Please verify from your ends. But however, as per the question, we need to give the answer here. So please give the answer immediately, whatever you think, which is the correct one. So which is the correctly matched here? Just give me the answer. Yes, the answer is 1, 3 and 4. This is not correctly matched. Rest of the are correctly matched. Okay. On which date of the statute of the International Criminal Court has come into force? किस डेट में इंटरनेशनल क्रिमिनल कोर्ट का स्टेट्यूट आया एग्जिस्टेंस में, इन फोर्स हुआ? ओके, 10 दिसंबर 2003, 24 अक्टूबर 2002, 1 जुलाई 2002, 1 जनवरी 2003. किस तारीख को आया? हालांकि क्वेश्चन इज वेरी ओल्ड वन, probably it will not ask because this question has been asked in the contemporary issues, and the question paper was belonging to 2003. But however, as a matter of fact, we need to understand, we need to answer this question. So just give me the answer immediately here. Fatafat. Yes, the answer is 1st July 2002. On this day, the statute of ICC, International Criminal Court, came into existence. Coming to the next question, under which article of the UN Charter the Security Council has the power to use force against a state? Okay, now give the answer immediately, fast. Article 41, Article 42, Article 2 clause 4, Article 24. Now this is a very important question, and this kind of questions are coming very oftenly in the prelims examination, of particularly of UP examination. So my dear friends, whatever the questions you are solving here, you should not answer incorrect in the examination, that is at least must be done from your side. So जो भी आप यहाँ पर पढ़ रहे हैं उसको एग्जाम में बिल्कुल गलत ना करें, क्योंकि क्वेश्चंस रिपीट होते ही हैं, यू नो दैट. ओके, तो फटाफट आंसर बताएं. यस, द आंसर इज आर्टिकल 24. Who can request the International Court of Justice to give an advisory opinion on any legal question? Okay, any member of the United Nations, the highest court of justice of any nation, the General Assembly of the United Nations, any permanent member of the Security Council. Who can do this? फटाफट कमेंट करें कि इंटरनेशनल कोर्ट से ऑफ जस्टिस से यानी आईसीजे से कौन एडवाइजरी ओपिनियन के लिए बोल सकता है. फटाफट. यस, yes, the right answer is the General Assembly of the United Nations. The C is the correct answer here. Okay, moving to the next question. Which one of the following organs of the United Nations performs legislative functions? Okay, which one of the following organs of the United Nations performs legislative function? The General Assembly, the Economic and Social Council, the Trusteeship, the Security Council. फटाफट आंसर बताइए इन चारों में से among four which is the right answer. A, B, C, D. Which is the right answer? Give your answer quickly in the comment box. Waiting for your response here. Yes, the right answer is General Assembly. It works as a legislative body, as legislative functions for the United Nations. Okay, so it is a legislative body for the United Nations. Okay, so this is how you can see. Oh, so this is how you can find here. So for United Nations, it is a legislative body. Coming to the next question, a new member of the United Nations is admitted by whom? By General Assembly, by Security, the Assembly, General Assembly on the positive recommendation of the Security Council, including concurring votes of the permanent members. The General Assembly on the positive recommendation of Security Council, including concurring votes of the permanent members. So now give your answers quickly, very fast. I am zooming in so that you can read the question paper. You can read the questions. फटाफट कमेंट करें. Give your response in the chat box. Yes, the answer is the General Assembly will admit on the positive recommendation of Security Council, including concurring votes of the permanent members. So this is how you can find this. Now next question. The Secretary of the United Nations is appointed by the permanent member of the Security Councils, by the General Assembly on the recommendation of Security Councils, in a joint session of Security Council and General Assemblies, by Security Council on the recommendation of the General Assemblies. So give the answer here immediately. The Secretary of the United Nations is appointed by how? By whom? So the Secretary is appointed by of the United Nations is going to appointed by whom? Give your answers quickly, fast. Waiting for your answer. Yes, by the General Assembly on the recommendation of the Security Council. So any person who wanted to be Secretary of the United Nations, he has to get the appointment to General Assembly on the recommendation of the Security Council. Coming to the next question. Legislative Assembly is the body created by whom? By Security Council, General Assembly, or the Secretary General, or G8, which is the, no, you can say that it is the kind of the body. फटाफट आंसर करें. गिव योर आंसर्स इमीडिएटली, क्विकली, फास्ट. Legislative Assembly is the body created by whom? Now answer is General Assembly. The B is the right answer. Coming to the next question, question number 139 of the question paper of the UP PCS Prelims Judiciary 2003. Which of the following country is not the member of SARC? Which is not the member of the SARC here? Singapore, India, Pakistan, Bhutan. Give your answer immediately, fast. The comment box. Yes, I know that you all know the answer. Yes, the answer is Singapore. Which one of the following states had proposed the creation of Tricoya in place of Secretary General of United Nations? So just give your answer. Which state has proposed the creation of Tricoya in place of Secretary General of United Nations? Answers are, options are USA, UK, China. फटाफट आंसर करें. Give your answer immediately in the comment box. Yes, the answer is USSR. Under which of the following the former president of Iraq, Saddam Hussein, has been granted the status of prisoner of war? Now, this is the old question. It is no more required to be answered here, but however, the question had been asked, so we need to answer, because this is a question which was asked at the time of 2003, when a lot of war was going on between US and Iraq, and then this kind of the question was there. But as per the answer, we have to see. So the Saddam Hussein has been declared as a status of prisoner of war, under which law? United Nations Charter Act, United Nations Charter 1945, Geneva Convention 1949, Hague Convention 1997, or the Pact of Paris. Give your answers if you have any clue about this. Yes, the Geneva Convention of 1949, he has been declared as a status of prisoner of war. Now coming to the next question, what is the name of the anti-terrorism law enacted by the USA just week after the September 11, 2001 attacks on World Trade Center? Again, this is a question which is very of contemporary nature, so maybe not be asked in the upcoming, but however, we will give the answer to this question. So the answer which of this question is US Prevention of Terrorism Act. So they have made another law on this one, anti-terrorism law. That is how you can find here. In India, we have another act of POTA Act, which was made after the war, after the attack on the parliament. So now coming to the next question, which country has declared in December, just a second. So which country has declared in December 2003 to destroy all weapons of mass destruction and abandon all programs to develop them? So which country has declared? Israel, Brazil, North Korea, Libya. Fatafat answer kare, give your answers immediately. Yes, the answer is Libya. Okay, now coming to the next question, first Muslim woman to win the Nobel Prize in its 2002 years. In its 102 years history is Taslima Nasreen, Benjir Bhutto, Shirin Ebadi, Nasifa Siddiq. This is old questions and this is not going to be asked, however, but answer is Shirin Ebadi. She was an Iranian lady and she has got the Nobel Prize for the peace. Now coming to the next question, who has been appointed as US civilian administration in Iraq after Saddam Hussein's ouster from power? Hans Bliss, Christian Gilmore, Salim Lohr, Paul L. Burmer. Again, it is not important, but the answer is Paul L. Burmer. My dear friends, you can see the nature of the questions which had been asked in 2003 on the international law. The questions are very much contemporary in nature. So you all need to read the recent newspapers, contemporary international development also, so that you can answer these questions in the examination as well. So this is how you can see it. Now coming to the next question, which is belonging to CRPC. Inquiry under Criminal Procedure Code is conducted by whom? Magistrate only, police officer, session court, magistrate or court? Give your answer. It is very easy answer. It is from section 2 of the CRPC. फटाफट आंसर करें. So कौन कर सकता है इंक्वायरी CRPC में? फटाफट आंसर करें. Give your answer. I am waiting for your response here. Yes, which is the right answer? Whether magistrate only or magistrate or court, both, or session courts or police officer? Yes, the right answer is magistrate or court. Coming to the next question, which of the following courts can try summarily offences mentioned in section 260 of the CRPC? Okay, any chief judicial magistrate, any metropolitan magistrate, any magistrate of the first class, especially empowered by the High Court in this behalf, all the above. Give me your answers in the chat box, in the comment box quickly. I am waiting for your answers here. फटाफट आंसर करें. Who can do a trial of summarily offences under section 260 of the CRPC? So right answer is yes. Give me answer fast. Okay. Yes. Which is the right answer? Yes. All the above. They can try this one. Okay. Coming to the next question, which one of the following combinations are not correctly matched? My dear friends, if you see the nature of the questions which had been asked in 2003, they are mainly about not correct statement or not correctly matched. Okay, so coming to this question which is not correctly matched, anticipatory bail, section 437 of CRPC, summary dismissal, section 384 of CRPC, appeal in case of acquittal, section 376 of CRPC, reference to High Court section 397 of the CRPC. So which is not correctly matched? Just identify here. I am zooming in for your reference here. Just go to this and let me know which is the right code. Okay, give your answer, put your comments, answers through comments to the chat box. Waiting for your response here. I am waiting for your response. Yes, anticipatory bail is not in 437, it is in 438. Okay, then coming to this one, appeal in case of acquittal, it is not in the section 376, it is in the section 378 of the CRPC. So it is in 378 of the CRPC. Now coming to the next is reference to the High Court is not in the 397, it is in the 395. So 1, 3 and 4, they are incorrect. Okay, the right answer is 1, 3, 4. Coming to the last question of this 2003 paper, the procedure for summary trial is provided in the following sections of the CRPC code: section 251 to section 259, section 238 to 250, section 260 to 265, section 266 to 271. Which is the correct option? Give me your answer here. I am waiting for your response. This is last question. So my dear friends, if you want this kind of videos on my YouTube channel, please subscribe my channel, please give your feedback, and so that we can improve more better videos for you, and we can have more question papers of UP prelims and other states also for your reference here. So please, your comments are valuable, your answers, your participations are very valuable, and we will go with this on your positive response here. Okay, so give the answer to this question here. The procedure for summary trial is provided in the following sections of the CRPC. किस सेक्शन में है summary trial का procedure? फटाफट आंसर करें. Yes, the answer is section 262, section 265. This is the right answer. Okay, so with this we have completed 149 questions from the law subjects of the UP prelims of 2003 UP judiciary papers, and we have finished all this. I hope that you all have liked this video. So please subscribe my channels, do your comments, share with your friends. I hope that this video will help you to do a revision, a review before the examination. It will help you also. It will help you to know the type of the question which is going to be asked. So with this note, I am really thankful for watching this video. Please support my channel. We are working very hard to improve our channel so that we can make more videos on law, on the competitive examination, on some other types of the examination. So thank you for watching this video. We will meet with another video very soon. Thank you.